Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us, coming to you from Washington's nicest indoor shooting facility. Of course, that is Security Gun Club right here in Woodinville, Washington. I'm going to get to talk about a state that I haven't had a chance to talk a lot about. It's the state of Missouri. A couple years ago, the state of Missouri and their state legislature, very concerned to protecting their citizens' Second Amendment rights, went out and passed a law which would basically forbid state government from enforcing any federal gun law, constitutional or otherwise. Well, of course, that got the United States government all in a tissy fit, and they turned around and essentially helped sue the state of Missouri. And when you see the reasons of what they're suing and why they're suing and what they're arguing, you're going to understand why the United States government is trying to cancel the state of Missouri. Okay, so what we're talking about today is Missouri's Second Amendment Preservation Act, passed in 2021 over concerns by a Missouri Attorney General that with recent case law development, some federal gun laws might be unconstitutional. How clairvoyant, as we now go through basically a serious gut check about the constitutionality of many of our pre-existing gun laws. What the state of Missouri did by passing their Second Amendment Preservation Act is they basically stated that no state resource in any way, shape, or form, nor state officer would assist in the enforcement of any federal gun law against Missouri citizens. And if, in fact, state government did assist in that, it would provide a Missouri resident with a cause of action to sue the state for deprivation of their constitutional rights and for violating the Second Amendment Preservation Act. The law went into effect in 2021, and it wasn't until almost a year later that the city of St. Louis County, filed lawsuit against the state of Missouri. But guess who jumped into the fray right afterwards? That's right, your Department of Justice and Merrick Garland, because, you know, they needed to sue the state also. Now, one of the central issues to this litigation involving Missouri statute is the 10th Amendment. We haven't had a lot of opportunity to talk about the 10th Amendment on this channel, but it reads as follows. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. And so that's a simple way of putting that. Other than the powers that have been enunciated in the Constitution itself, the federal government has no other powers. All of those powers go to the states. Now, if you take a look at the full United States Constitution, you will see that there was really no federal regulation delegated for the controlling and regulation of firearms. It's always been done through the federal government's ability to regulate interstate commerce. That interstate commerce clause is the catch-all that has allowed the federal government to regulate dang near every industry in the United States. Now, the other thing we need to understand the absurdity of this lawsuit by the United States government is the grounds upon which they're suing and the grounds upon which the court ultimately found this statute to be unconstitutional. Now, for those of you who geek out on this channel all the time, you will know that anytime we have new legislation proposed, there is always a preamble, a purpose section, a reason, the justification by which the legislature believes that this statute is necessary. Now, there will be a lot of hyperbole will be put in there. There will be a lot of argumentative language. It will be very inflammatory in nature, and that's the way all legislation, whether it comes from conservatives or liberals, is always written that way. But it is the actual statute itself, the operative functions of the statute, that determines its legality and or constitutionality. Well, except in this case. Instead, what the United States government is saying is that the reasoning that the Missouri state legislature decided to pass this legislation, which is they were concerned that recent case law developed had rendered many federal gun laws unconstitutional. The United States government asked the court to throw out the entire law because the reasoning of the legislature, the non-operative section of the statute, was wrong. As a matter of fact, as the plaintiffs put it in this, the United States does not dispute and has in fact conceded that Missouri has a right under the 10th Amendment not to lend its resources to assist federal enforcement. So the United States instead sued under a novel theory that a state cannot exercise its 10th Amendment authority if the state's factual reason for doing so is mistaken. That's right. The premise under which you passed the law was mistaken, and therefore the entire law is unconstitutional. Now, who would ever actually buy off on that argument? Oh, well, a Barack Obama appointee judge in Missouri did when they found the district court accepted this novel theory. At the federal government's invitation, the district court focused not on what the state law does, but on the legislature's reason for passing it. Fixating on the statute's legislative findings, which are, of course, purely declaratory, the district court concluded that the Missouri General Assembly's statement interpreting the Second Amendment is itself unconstitutional. And because the General Assembly's interpretation was central to the reason that the legislature directed state agencies not to assist with federal enforcement, the district court struck down the act in its entirety. Aggravating that error, the district court did so even though no named defendant is authorized to enforce the law. So the title of this presentation is When the United States Government Attempts to Cancel the State of Missouri. And what you can see here is that that is exactly what is occurring. The United States government is suing the state of Missouri to wipe from its books a law passed by its state legislature, properly passed by its state legislature, because they disagreed with how the state attorney general interpreted current case law related to the Second Amendment. They're not arguing that the law itself, that the operative clauses somehow or another are unconstitutional or violate constitutional provisions. They are claiming that the entire law is unconstitutional because they disagreed, they didn't like the opinion of the Missouri Attorney General. And so this lawsuit is nothing more than an attempt at cancellation of Missouri's sovereignty. Now, what's even more disturbing is even though this law remained in effect for a year and a half, the district court judge that we previously mentioned actually struck it down as unconstitutional. The plaintiffs then appealed to the Eighth Circuit. The Eighth Circuit issued a one-sentence ruling upholding the finding, and which literally could have been scribbled on a cocktail napkin. The plaintiffs in this matter, the state of Missouri, have now asked Justice Brett Kavanaugh to review the order of the Eighth Circuit. Why Justice Kavanaugh? As we know, each Supreme Court justice is assigned a circuit to supervise, and the Eighth Circuit is supervised by Justice Kavanaugh. So there is currently a pending petition to Justice Kavanaugh to have him review the Eighth Circuit's affirmation of the finding of unconstitutionality on the Missouri Second Amendment Preservation Act. Now, as we know, this will put it on an emergency docket, which will allow Justice Kavanaugh to do one of many things. He could refer it to the entire panel of judges. He could set it for oral arguments. He could take sua sponte action on his own. We're going to have to very carefully watch this case to see what developments are. This is a huge, huge battlefront because the United States government here is attempting to invade the sovereignty of the state of Missouri and claiming they can do so because they disagree with the factual premises upon which the law was passed. This is yet another example of the gross overreach that we are seeing from this particular presidential administration. The case, once again, is Missouri versus the United States. We'll link it all up down below so you guys can geek out on yourself. And of course, we will very carefully watch this case to see if there are any other developments. In the meantime, if you guys get any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to contact Washington Gun Law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.